Okay. Well, I'm going to go ahead and kick it off. Welcome, everybody. It is Tuesday night. I don't know where everybody is, but I can say in Maryland, it is dreary and it is a perfect time to talk about contracts. So thank you for joining us for the second session of Aftercare Industry Month, brought to you by Thoroughbred Education and Research Foundation. I'm Kirsten Green. I'm the Executive Director of the Retired Racehorse Project. And with me this evening from the Dinsmore group, we have Laura Holoubek and Anne Guillory. They're going to be talking to us about putting the correct provisions in your adoption contract or bill of sale to protect you, to protect your buyer or adopter, and to protect the horses. And we're going to talk about some common misconceptions and oversights that we see when people are putting together those documents. Before we get kicked off, I'm just going to cover a little bit of background information and some housekeeping. So Aftercare Industry Month is a progression of a program called the Aftercare Summit, which we used to run as part of the Thoroughbred Makeover and in conjunction with Thoroughbred Charities of America, Thoroughbred Incentive Program, and Thoroughbred Aftercare Alliance. So like all of the alphabet soup organizations got together and wanted to offer an afternoon of education. But when we're at like an event that everybody's been working towards for a year, like nobody wants to sit down and learn stuff in the afternoon. So we're kind of capitalizing on trying to do that at a different time of the year. The RRP as an organization, why do we host this? Education is one of the core tenets of our work. We're out here trying to increase demand for thoroughbreds, and we think that educated owners and empowered owners translates down to the horses and what's in their best interest. So we're hosting these topics this month, and we also want to focus on the fact that we believe that aftercare is for everybody, regardless of your tax status, your business structure. There are so many different ways to participate in this industry, so we want to make sure that there is good information out there for you, no matter how you participate. So from a housekeeping perspective, we will be doing just a little bit of kind of quizzing and interactive like what's missing from this, like guess what the missing language might be here. Please feel free to use the chat for that. If you have a specific question, I want to make sure that it doesn't get lost in chat. So please use the Q&A function so that we make sure to cover those specific questions for you. If there's anything that you need help with or anything, I'm primarily here just kind of moderating, so feel free to message me directly. And with that, I'm going to kick it off to Laura and Anne. Please take a minute to introduce yourselves and we will get underway with your presentation.
Terrific. Thank you guys. Thanks for having us. We're excited to be here tonight. We're both big advocates for horses in general and adoption and rehoming. So we are both partners at the law firm of Dinsmore and Scholl, which is a regional firm. We have about 800 lawyers across the country. But Anne and I, and we have 4 or 5 other partners that do a lot of equine work. So my background is I grew up in Canada. I showed ponies, evented, and now show jump. I've done a lot of other things like reining and polo and fun things. But definitely horses are my passion, and I'm grateful to have my partner Anne Guillory here, and I'll let her introduce herself.
Hey, good evening, everybody. Anne Guillory. I'm in the Louisville office of Dinsmore. I do more of the litigation and risk management side of my equine practice. In my other hat, I am a tort litigator. So if someone gets sued, I get hired to defend the person or the company that's sued, and sometimes they intersect and I get to defend an equine related client. I've done everything from products liability to slip and falls, but equine is my passion. I grew up in Bowling Green, Kentucky, going to the county fairs and showing American saddlebreds, and I still ride saddlebreds today. I was actually riding one this afternoon, and she stepped on my toe later, so it went well. And I'm a lifelong racing fan. I've followed racing since before I was old enough to put my money on the window at the betting window. So happy to be here and happy to have this discussion.
Okay.
So Anne and I will approach our comments probably from a little bit different perspectives and give you both sides. So I'm a transactional contract lawyer, and Anne, as she just mentioned, is a litigator. So she knows what can and does go wrong. And then Kirsten is going to monitor the answers to any of our questions and forward your questions to us. So feel free to jump in at any time. And then I just want to say, which we have to, we're apparently obligated to say, so we are not your lawyers. We are not providing legal advice on this call. We're purely entertainment at this point. Just kidding. But our suggestions here, Kirsten had the brilliant idea to have some contracts submitted that we can go through and talk about the good points and the points that could use some improvement. So we're here to just point out the issues for you to look at, both when you're drafting it or looking at one that your attorney has drafted as a seller, or when you're looking at it as the buyer or the adopter. But remember that every deal is different. And so you should consult with your attorney as you're drafting any forms. So I'm going to kick it off to Anne, who will run the slideshow, and we'll start with a sample bill of sale. So we get a little deep in the weeds early on, but then we'll skip ahead to other agreements and you'll start to see the consistencies or inconsistencies between agreements. So you can start to look at them with a critical eye. So this, just generally, why do you need a bill of sale? This is for your entertainment, but you know that what can go wrong will go wrong. So having a bill of sale, we're going to go through sort of the elements of a bill of sale and why you really need one, because every deal is different, every horse is different, and particularly if you're going to adopt out thoroughbreds, there's lots of issues to consider in your adoption agreement. So one of the things to think about that I think most people don't know is there's a federal sort of act called the Uniform Commercial Code. The interesting thing about it is it's not uniform. It's supposed to be uniform across all 50 states, but each state has made its own modifications. For instance, in Kentucky, we have very specific, not surprisingly, equine provisions and provisions for public auction. So knowing what state you're in and looking at your code, any sale of a horse over $500 is required to be put in writing through a bill of sale. And it documents the transfer of ownership as opposed to breed registries, which sometimes document ownership and sometimes don't. So you may know that the Jockey Club does not want to be an ownership registry. They're a breed registry and a pedigree registry, but they do not guarantee title. It's not like transferring your car. So the bill of sale is what proves who owns it and when, and what the terms of the deal are.
And the other aspect from why you would want a bill of sale, other than sort of to take advantage of the Uniform Commercial Code and ownership and title issues, is the risk management component of it. And this is the part that I see as a litigator when things go bad. And so one thing is you can use your bill of sale, and I think a good way to think of it is from a risk management perspective, when you're looking at what needs to go in the bill of sales and the things that we're going to look at later with provisions and some of the examples. It shifts the burden from buyer to seller. So you can shift the burden of what we call risk of loss. What is the risk if something goes wrong? And how do you address that and provide for it and plan for it as best you can in the contract in advance? It also avoids or lessens the chance of future disputes. It may not stop a dispute, but a really well-written bill of sale can discourage someone from having buyer's remorse or a seller from having an issue. Normally, if you're going to have an issue with a bill of sale, it's going to come from the buyer. But it avoids, if a really well-written bill of sale bakes everything into it. It shows the parties' work and their thought process in the transaction, and it can lessen the chance of a dispute later, or at least lessen the chance of a dispute going into litigation later. It also takes advantage of states that have limited liability statutes. I think it's either 48 or 49 states right now have an equine or farm animals activity limited liability statutes. Some of those do require, including in Kentucky, require statutory language, require the warning to be in any written contract related to equine or farm animal activities. And so you can take advantage of that baked in limited liability that protects you if I'm the seller and I'm selling a horse and something happens later and someone tries to sue me for an injury that the horse caused, then I can take advantage of the Kentucky Limited Liability Act if I have the language in the contract. It can also documents the sale process. Like I said, it kind of bakes in and shows what your work is and what the party's thought process is and the things that they considered in entering into the transaction. And it also offers a way to control the location and the law for any dispute. And we'll look at some specific provisions that address that. We call them choice of law and choice of venue or choice of court provisions. And so that we will look more at those, but it's a way to control those that as a seller, you can manage if there is a dispute and it does go into litigation, where do you have to litigate that?
So we described these as your sort of ride or die provisions. So you want to have, and we'll go through as we pull up a sample agreement in a moment, we'll go through these in detail. But you want to have a warrant as the seller, you want to have a warranty disclaimer. You want to address whether a pre-purchase was done and what language you want to say, you want to include in there even if somebody waived the pre-purchase. Ideally, people that come to look at your horse to buy or lease should have a professional advisor, and you want to recite that in your agreement so that they know they weren't relying on you as the seller. And then as Anne mentioned, choice of law and venue, which is where an action would be brought. The limited liability statement, which for instance in Kentucky has to be directly above the signature line in all of your agreements, in addition to posting the warning signs around the farm, etc. Attorney's fees, you want to include an attorney's fee provision in your agreement because, for instance, in Kentucky, if you don't have it in your contract, you won't get attorney's fees except under very limited circumstances. No right to return. I'll show you this in some sample language in a later slide, but we've had a lot of activity over the past few years with people trying to return horses long after the purchase, after their kid pulls on the reins for 6 months and the horse starts stopping or whatever the issue is. So we want to be specific about that. As a seller, you want to try not to represent both sides because it opens you up for a lot of other claims of having presented the horse for a particular purpose or having certain qualities. And then ideally do not use forms from the internet. I got one just the other day that it's super clear that it's just came out of some random AI generator or something because it had language in it that didn't make any sense. So those are just sort of those are kind of the big ticket items, and then we'll move on.
All right, we thought going through some of the forms that you all submitted would be helpful, and it's not a criticism, it's just issue spotting and the way that we lawyers think about things, because we see so many of these and we see kind of what happens when the language isn't baked in there. And you could sell a horse with a bill of sale that's okay or is missing some of our ride or dies and be fine 90% of the time, but it's the 10% that's going to cost you. And so we just want to issue spot and provide you with questions to ask and provisions to think about moving forward as you do bills of sale. The first one we're not going to look at, it's the RRP form bill of sale, and we're not going to look at it right now. It's in pretty good shape, and it's pretty complete so that's an example that we throw out and is available as a pretty solid bill of sale. But as we walk through these others, you may have questions about things. Well, I can add this to my my form that I use, or I can add this to what I've used in the past. So the first one we're going to look at, if my link works, is the horse purchase agreement. Let's see if I can get this there. Okay. And I'm going to try to do this slowly. This didn't really lend itself to cutting and pasting into it, but someone submitted this bill of sale and a horse purchase agreement. And we're going to spend pretty significant amount of time going into this form. And then we're going to skip kind of going over some of those provisions in the other examples that we're going to look at, because everything builds on one another. Like all of the provisions that we're going to discuss will apply moving forward to any other bill of sale or lease agreement or adoption agreement moving forward. And so just at the top, we have a place for the buyer and the seller. And we also have a description of the horse to be purchased. And I want you to think about why it's important to identify the parties and get an address and a phone number, particularly these days when a lot of people only have their cell phones. You are going to want to identify everything with current information, identify people by their full name, name that they would sign a legal document on, with address and phone number, because what if you need to contact them because there's a problem, if they don't pay, if you want to know where they're living, where their home state is, because that could inform your decisions later on in this, further down in this bill of sale, as to where any dispute would be litigated. And you also have to consider sales and use tax, and where each party is located is going to inform that decision too. The next part is the horse to be purchased. And this one does a good job in that it has name, date of birth, sex, color, breed, and it has 4 photos of the horse as well, which is very specific. And so I think is it enough to just give the name? Like if the horse's name is Celeste, and that's what she's called around the barn, but is that the registered name? Is there a registration number? Is there a breed registry? The Uniform Commercial Code requires goods, which horses are considered goods, to be identifiable in the contract. So you've got to be able to look at the language identifying the horse in the contract and be able to identify that horse, that good, from all others. And so this contract does a pretty good job of that, particularly including the photos. But I would encourage, if there is a breed or a breed registry, a tattoo number, to include as much information as possible. Obviously include the registered name regardless of what the horse is called. Identification of sex can be an interesting topic. And when you think, well, mare, stallion, gelding, like that's pretty much it. But it's important, depending on the purpose of the sale and the intended use of the animal. Think about if you are selling or leasing a brood mare. Is it a maiden mare? Is it a mare that does have a history of getting in foals, staying in foal, and delivering healthy foals? Is it a mare that has been examined and determined to be reproductively sound, but has not ever been bred or carried a foal to term? Is it a ridgeling? Is it a stallion? Is it a gelding? What is the purpose? And think about what the purpose is if it's a contract for something other than a riding horse, or really for anything where there is an intent behind the sale that relates to the sex. And this is particularly for stallions and mares. Did have a sale once where the mare was thought to be reproductively sound, would be suitable for breeding. The mare actually turned out to be genetically male, which caused some problems down the road. But think about those things when you are identifying the goods and identifying the horse in the contract. we keep on
Let
going.
me just jump
Yeah,
in there for a second, Anne. So I think particularly with this audience where most people are talking about thoroughbreds, then it's, you know, being able to use the microchip number, or with USDF horses, which are now all must be microchipped. That's literally the best way to identify the horse, in addition to a physical description. I've never seen anybody put photos in a bill of sale like this, but I kind of love it. So good job on that.
yeah, me too. I like the pictures. I'd like to know how they got them in there correctly sized, and in focus. But and then the next section is the consideration, which is the money that's being paid. So that's pretty straightforward. It's a straight total sum. You pay this, you get the horse. The next one that I want to flag is number 4, and that's the ownership. It says as of noon on whatever day, the buyer is the sole owner of the horse. I think, you know, think about what's wrong about, or what could be, not necessarily wrong, but what could be concerning or could cause issues in having the noon time transfer. What time zone are we in? Is there an issue where there's an international seller or buyer, where you could actually be on a different day? You know, risk of loss. This is a transfer of risk of loss. And so risk of loss is at noon, this horse is yours. And if the horse proceeds to do something silly or hurt itself or get sick from that point forward, that is on you, buyer. So that is a shift of the risk of loss from the seller to the buyer. And it's important in your bills of sale to identify when that happens. And so it could be, generally it transfers when the buyer picks up a horse. And that's called acceptance of the horse or acceptance of the goods. If the buyer comes to the seller's location and picks up the horse, that's traditionally transfer of the risk of loss if it's not otherwise specified in a contract. It also matters whose insurance covers. If the seller maintains insurance on the horse, and then the buyer also has a policy on the horse, you need to make sure that the bill of sale specifies that the risk of loss and the policy, one policy terminates, the other policy picks up, and you got to make sure there's seamless coverage there for risk of loss. Other things to consider, just generally on the same topic, is should a seller deliver the horse to a buyer? And why or why not would you want to, as the seller, deliver the horse to the buyer versus the buyer coming to you to pick up the horse, versus having you know, having a transport company, having a third party carrier pick up the horse and transport it. And things about that, and it's similar to, it's all about the risk of loss and managing the risk of loss. What's the risk of injury? If I'm the seller and I'm going to trailer the horse over to the buyers and something happens on the trailer, do I really want that? If I'm the seller, I'm going to want the buyer to come get the horse, or hire their own third-party carrier, their own trucking company to come get and transport the horse. You know, again, that covers insurance. And again, think about if you use a common carrier, if you use a third-party transport company, they're going to use something called a bill of lading, and it applies to horses and any other goods that a common carrier transports. And it usually includes a limitation of liability that is a few $1,000s, maybe 5, maybe 10 at most. And so in a lot of cases, that's not going to cover the risk of an injury or a loss of the horse. So give some consideration to that. And whatever you agree with, whatever the seller and the buyer agree, that's fine. Reduce it to writing so you show, you have it documented in the bill of sale when that risk of loss and when that ownership transfers. And it also says, forthgoing, any veterinary bills, insurance, boarding bills, or other expenses will be at the expense of the buyer. Forthgoing is legalese, and as lawyers, we will tell you to try to avoid legalese so that these contracts are readily understandable. The standard for contract interpretation in courts, in most courts, is generally the plain language, the plain and ordinary meaning of the terms. So there's there's no need to put a lot of legalese in these contracts. You want them as simple as possible. Okay. Let's see, we've got payment terms, which is important if you're going to do a transfer versus a check, or like a cashier's check, or a briefcase of small unmarked bills. However it is, it's good to include that with the consideration of the purchase price. The next section is the warranties. And as Laura mentioned earlier with the UCC, and on the sort of why you need a bill of sale, is one of the things you can do is you can control and disclaim any warranties as the seller. This language could use some beefing up, and in specifically the UCC is going to require, and we'll look at some good examples, is going to require conspicuous, and that's the word, conspicuous language that disclaims all warranties. It uses things like, this includes the fitness for a particular purpose, and that warranty, the fitness for a particular purpose, is a warranty that the horse is suitable for a particular use or a particular level or a particular discipline. You also want to include warranty of merchantability, which is that the horse is a good and is warranted to be sold, to be merchantable and usable. You also want to include language that the horse is sold as is. That eliminates any discussions you may have between buyer and seller, that anyone that the buyer could later claim is, well, you suggested that the horse might be suitable for this discipline, but it turns out they're really not, and that's what I had my heart set on, and you warranted the horse for that discipline, and now I want to return him and get my money back. So this warranty section, it checks some of the boxes. And it does say that it makes no warranties express or implied, including the warranty for the fitness for a particular purpose. But it needs to be conspicuous, and so most of the language you'll see is in all caps. It needs to include warrant language about the warranty of merchantability, and that the horse is sold, and use the term as is.
And I think you tell us, because you're the litigator, but even if you forgot to include the disclaimer of warranty, but you say the horse is sold as is, that's sort of an overriding disclaimer. Is that correct?
Yes, I would, if I was representing the seller, I would argue that mentioning that even if it wasn't conspicuous, they classified the condition as the horse is being sold as is, and that should be sufficient to document the condition and the terms of the sale. It may not get the case dismissed outright, though, which is why it is important to use the conspicuous language with the as is.
So let's throw out a question, Kristen, to everybody on the call about, we're kind of to the end of the agreement. What things are missing from this agreement? Does anyone, I know you can't see the whole thing at once, but we've kind of covered the main topics in the agreement. What sorts of things are missing that you might include in a bill of sale? Does anybody have any ideas?
Please feel free to drop your ideas in the chat so everybody can see. And I do have a question from the attendees that I'll share with you guys to think about while we see if we get any responses. This is a good one because it could apply in a number of different situations. For a horse who is staying on property beyond the purchase or adoption date, would you recommend including a clause in the contract or having a separate contract for boarding/transport to go into effect after X action or date?
Yes, and we will look at, yes, all of those things, and we will look at some examples. Well, one place that I see it most commonly is in adoption contracts or adoption agreements, because the person may be adopting a horse, and then the horse remains on the premises for a certain amount of time before the adopter can come and get them. But yes, and it doesn't have to be a long provision. It can be just a paragraph about that it is there's also included a boarding provision, And that you can be very specific about when the risk of loss, when the ownership transfers, and you can address that, and the fact that the horse is going to be staying for board along in that, all in that one paragraph in that provision.
So some of the ideas from our attendees about what might be missing from this sample contract would be possible penalties, right of first refusal.
Those are great ones. So I think it's interesting, the second agreement that was submitted checks some of these boxes that were missing in the first agreement. So I think, Kristen, did you circulate the article about the non-uniform provisions between Florida, California, and Kentucky?
Yes, attendees should have gotten that included in a reminder that was distributed, but I will get that link and drop it in the chat as well.
Okay. So there's Kentucky, California, and Florida, which are some of the principal equine states. There has been substantial litigation arising out of those states related to fraud, particularly in the public auction world of the thoroughbred industry. That litigation resulted in those states passing specific bill of sale statutes, even though it's already required under the Uniform Commercial Code that any sale of a good, which is a horse included, over $500 has to be in writing. These 3 states passed specific legislation. And they're all, of course, somewhat different. So depending on what state you're in, you need to be aware of those requirements. But those lawsuits in the thoroughbred industry typically arose out of undisclosed dual agency and fraud. So not only was the agent working both sides of the deal, but the agent was misrepresenting the sales price of a horse to the buyer and the seller and pocketing the difference. So charging the purchaser a higher price, pocketing the difference between what the purchaser paid and what the seller thought the horse was being sold for. The big case in Kentucky was the Just Jackson Stone Street case, and you can find that probably online. But so some of the provisions we'd like to see added to this agreement are a dual agency provision that says either there is a dual agent, both parties consent, which is fine, or there is no dual agency. Commissions should be disclosed. The horse industry typically hates this, but really needs to be included. One of the things the UCC requires that when you purchase a horse, you do a UCC search, which is online and typically free, of the seller. And if you look, you'll see any liens against the seller on any bloodstock. It's very prevalent in the horse and in the thoroughbred industry in particular, that banks will file liens against the bloodstock that they have loaned money against. So you really should do that, and you can usually do it for free yourself. With sport horses, we want to see a provision about pre-purchase, that the pre-purchase exam has been conducted or waived, that if it was done, it was done by a veterinarian representing only the purchaser. And we strongly recommend to sellers that you don't recommend veterinarians, because that's where, if then down the road the person has a problem or finds an issue with the horse, they'll come back and say to you as the seller, well, you said we should use this vet, or we used your vet, and they have a conflict of interest. With sport horses in particular, I like to use a provision, which I'll show you in a moment, that says, I rode the horse, I tried the horse, I had a professional advisor, and I decided myself that the horse was suitable for me. And as a seller, you don't want to make any oral statements that the horse is suitable for a particular rider unless it's your client. And then this agreement also, most sales, I know people hate to hear this, but most sales of sport horses or thoroughbreds being used for a second career are subject to sales tax in the state you're in. If the horse is immediately going to leave your state, it's possibly subject to what we call use tax in the state that it travels to. there's exemptions around that. You need to talk to your accountant about that, whether you are subject to an occasional sale exemption, but in general, sport horses are subject to sales tax. That doesn't mean people collect it, but it means it's typically due. And then the attorney's fee provision, which you need to recite in your agreement in order to have it be enforceable. And then your Equine Activity Liability Act language before the signatures, depending on the state you're in. Kentucky requires it to be in your contracts. New York, for example, doesn't. So yeah, that's where we are with that. So do you want to go to Anne, do you want to speak a little bit to the fraud issue, or do you want to move on to the next agreement?
Just briefly, on fraud is that, it varies from state to state, but the most important thing to know is that in most states, it requires you to make what's called a material misrepresentation that is false at the time you make it, and that you know, or reasonably, or you know it, or you make the misrepresentation recklessly, which means you either say something about the horse and make a representation that you know at the time is completely wrong, or you're reckless about it and you don't really, you're like, it'll be fine. And the buyer buys based on, in other words, you induce them to buy the horse based on those misrepresentations. So they've acted in reliance on your statement, and then they're damaged as a result of that. And the important thing to know is it can expose you to punitive damages. It's fraud you've got to put the person back in the position that they were in before they made the decision to buy the horse. And so that's all the money back for the purchase price, all the board and medical expenses if something happens. And then you can get punitive damages, which are meant to punish you on top of that. And those can be multiples of their underlying claim. So just having a warranty, or having language about warranties, and having your bill of sale locked down and have all of the information in it is important in avoiding and things like not suggesting a vet to use, and having language about a pre-purchase exam. That's important to protect yourself from claims of fraud or negligent misrepresentation or fraudulent misrepresentation later.
Just a couple of comments and questions as we transition to the next document. Kyle brought up a really good point about right of first refusal, but correct me if I'm wrong, I think that's going to be a policy that the organization or the business holds, that on a case-by-case basis that they want to write into their contract, not something that's necessarily going to be required by local law. And then as a specific question, which I think is another really good one, Kyle, by sharing or promoting your primary veterinarian on your website and social media, can that be considered a recommendation if the veterinarian is used by a buyer or adopter, even if it was not directly recommended to the individual?
So I was just going to address that right of first refusal and the penalty question. They're both great. And those come up often, particularly in the adoption agreements with the Thoroughbred adoption associations. Rights of first refusal are great to include. And sometimes people with their personal horses will include those as well, that if the horse is going to be sold down the line, you have the right to purchase the horse at whatever the offer is that somebody has from a third party. Those are definitely enforceable. With penalties, and I'm going to assume what we're talking about here and correct, and you can drop it in the chat if you're talking about something different, but there are some of the adoption agencies that include a penalty if you, for instance, sell the horse within those first 12 months, or if you don't submit your physical photos to show the condition of the horse. And I'm trying to think what else, like if a horse ends up at a kill pen, which hopefully doesn't happen. Some of those associations include a provision that says you'll pay us as sort of liquidated damages, $10,000 or $5,000. I will say, and Anne can step in here, it's worth including, I think, as a deterrent, because a lot of people will read that and think, oh, I better not do this. But they would be very difficult to enforce in reality.
I agree. I think it's, you can include them and make sure they're written plainly and clearly. The issue is in enforceability and how much money you want to spend to enforce them on the back end of things, but it does provide, I mean, it does show the intent of the agreement from the outset, and that both sides have signed to it. So I think it is important to include that if you want a right of first refusal or you want penalties, and then the organization, the seller, can determine later on a case-by-case basis whether they want to pursue those.
And then the other thing I've seen, and I think we might have an agreement that even includes this that was submitted, is where your agreement says that there's a penalty for certain things, or you can't resell a horse, or certain provisions in your agreement with between seller and purchaser need to be included in the next agreement. So if I sell to you and then you sell to Anne, it has to be in your agreement between you and Anne. That becomes very difficult to track and very difficult to enforce, because you don't have what we call privity of contract with that next purchaser or next owner. It's, I still say it's worth including in the contract, because most good people will try and honor that. But as you know, as the sales get more remote, and you're now 3 or 4 people down the line, whether someone remembered to include that, or if that horse stepped up and became a very competitive show horse, the purchaser may not agree to that. And it would be difficult, because you're now a little bit removed from who owns the horse now, to enforce it. But it doesn't mean it's not worth, including in your agreement.
We have a great question here from Lindsay, who is working on the backstretch up in Canada, actually. And I think this is a situation that is a bit more unique to people that are, working in racing stables and doing a little bit of kind of in-house aftercare, or people that are serving as like a listing agent type of capacity, where they're just trying to facilitate the kind of parts of the sale. And so her question is, when you're working on the backstretch, you're limited to whoever the licensed vets are that are working on that backstretch. So what can you do to facilitate that information for that buyer without it being construed to be any kind of recommendation? My thought would be to, if there's a condition book or some kind of like official publication, or, the website of the track that lists those personnel, which I would imagine that there would be something like that. That would be a kind of like neutral reference that you could point somebody to. But please, Laura and Anne, if you have anything to add.
That's a great question. And I'm Canadian, so I'm thrilled that there's someone from Canada watching. It's a great question, because I think the key is not to recommend your treating vet. So if you have a horse and there's a veterinarian on the racetrack who's been the treating vet on that horse, that should not be the vet that provides the PPE for the purchaser. Because you put your vet in an awkward situation where they have to decide what they disclose about what they know about the horse and what they don't. What I like to suggest to people is, you can certainly recommend veterinarians or have worked with in the past, maybe that aren't the treating vet for that particular horse. I like to say to people, recommend at least 3 people, and give them an option to choose between 3 good. If they don't know it, if they say, I don't know anybody, who on earth would I use? Then I'd like to say I would do the same with real estate agents, or if I was referring accounting firms, and give somebody 3 or 4 recommendations for them to, have a quick chat with and decide if they're a good fit.
Okay, so let's look at this lease to own option, because I think that's gonna, where you've got a trainer who is, selling the horse to a client, or doing a lease to own situation. I think that's going to cover some of the concepts, kind of like Kyle brought up, where the horse is going to be staying on premise.
Yeah, so this agreement, it starts off really well. But later, as you go through the agreement, it looks like some additional components were cut and pasted, probably added over time. to maybe an agreement that was prepared by an attorney at some point, you end up with some components that are added, like this clause that doesn't really have a title, and then you see the numbered paragraphs kind of go away, and you end up with a little disorganization here as you move through, and you end up with titles instead of numbered paragraphs. And so while it checks some of the boxes that we like, it does get a bit disorganized as you go through, and it may seem a little picky, but organization and keeping things organized and readable in your contracts and your bills of sale, your leases, adoption agreements, everything is very important, because that lessens the chance of someone saying, well, I couldn't follow the contract, or I didn't know what that referred to in the contract is. So try to organize, when you're looking at your bills of sale, try to think of them as being organized topically. And, you know, I like using the paragraphs. I would say you can see in places like 3, there's like 3.1, and then there's 3.2, and down here there's 4.1. I would say make those, you know, separate, move them down to their separate lines, so that it's much easier to find a provision quickly in them. But overall, it does have things that we like that were not in the other ones, such as the disclaimer of warranties is right here, section 4. And it is very clear. It says this is an as-is sale. It uses conspicuous language in all capital letters, disclaiming express or implied warranties. It includes warranty of merchantability and fitness for particular purpose. It states that the horse is free of all liens, and that the seller has no liens or encumbrances on the horse. So that's good. I mean, it's belt and suspenders. Do your UCC search for any liens, but it's good to have, if you're a buyer, you want the seller to, you know, expressly state there are no liens on the horse. It covers a pre-purchase exam, and has a pretty good provision on that. Now it says that the purchaser warrants that they have had the horse inspected. So my suggestion here would be, and if in this actual specific sale that this came from, there had been a pre-purchase exam, then this is fine. In general, though, a bill of sale should say they've either had it done, or they've known they could have it done and they've chosen not to. So they've waived their right to do that. Paragraph 6 has the risk of loss, and it states that upon transfer of possession of the horse, as defined in 3.2 above, the buyer assumes all risk of injury or loss to the horse. So that goes back to, if you scroll back up here, 3.2, transfer of possession. You know, the seller will tender the horse to the buyer at the horse's location upon receipt of the purchase price. That's, you know, it would be better to specify the horse's location and receipt of the purchase price, what actually qualifies as receipt of the purchase price. If it's a wire transfer, it's pretty easy, but it does have address the risk of loss. And then it also has an attorney's fees provision in it. And this is what it would look like in the event that there is some kind of action brought in connection with this agreement or to enforce the agreement. The prevailing party, so the party that wins, shall be entitled to recover from the losing party reasonable attorney's fees, costs, and expenses. And so that's a good attorney's fees provision. It also has this stipulation in it, which is about, you know, the horse will never be sold or rehomed or given away to a kill buyer. And it's voicing the intent of the parties at the time of sale, but it does get contradictory, because as you read down further, it provides for, the buyer agrees to pass this responsibility to any future buyer in the event of a future sale. So that's contradictory. You start out here by saying the horse will never be sold. And you could read it as sold, rehomed, or given away to a kill pen or any auction. Or you could read it as being the horse will never be sold, period, under any circumstances. So that introduces some ambiguity into things, and you want your contracts to be clear. And so it probably needs clarification, perhaps a statement of intent by the parties, that the intent is to assure that the horse has a good home for life and is never placed in a position that negatively impacts the horse's physical health. And then set forth, what the requirements of transfer. Is there a right of first refusal? Do you have to approve the home that it goes to? Do you want the subsequent buyer to incorporate the terms of paragraph 9? 10 is something that I like to include in all contracts. I call it a merger clause. It states that this contract contains all agreements between the parties, that anything discussed preliminarily, any drafts considered, any, numbers written on pieces of paper, passed back and forth, everything is merged and incorporated into this agreement. And this agreement contains all the terms among the parties. And that means if somebody says, well, so-and-so told me later, or so-and-so agreed to modify this in writing or modify this verbally, you can look at paragraph 10 and it says it will not be modified or amended unless by a written instrument in writing executed by both parties. So that kind of avoids the he said, she said, or she said issues later.
So that provision is really important for those people listening, that if during the course of the trial of the horse, or you're showing the horse to someone, you've made certain comments about the horse, and we'll talk about puffing versus actual warranties in a minute, but this is where, this is not a license to say stuff about the horse that's untrue, but if you have said, oh, I think it would make a really good amateur owner hunter, or I think it would do this job really well, this clause says if it's not in this agreement, it's not part of our deal. And that can really help you as a seller down the line if someone were to come back and say, but you told me the following. And first, there's no way to prove whether you said it or didn't say it because you were in the middle of the arena at the time. But this will help you, this is a tighter agreement. And then I love this agreement because I think it's so instructive. If you guys don't remember anything else from this call, the difference between this idea of lease to own versus a lease with an option to purchase from a transactional lawyer point of view is so important. So what they've set up here is a payment plan to purchase the horse over time. But the way it's set up, title to the horse would transfer upon execution of this agreement. And then the purchaser makes payments over time. So it's a little bit like furniture layaway. Like you accept that in this case, you get physical possession of the horse and you get title, but you haven't paid. So in order for this to work, to protect the seller who's still owed money, you would have to combine this agreement with a promissory note to pay the full purchase price and a security agreement that gives you a security interest in the horse that's not yet fully paid. And then ideally you file a UCC-1 financing statement with the state where the either the purchaser is or the horse is, depending on what the situation is. I would much prefer, if you're my client, that you do a lease with an option. So it would work out the same, but for title doesn't transfer until the end of the payments, and you don't need all that extra documentation. So the way that would work is you would say, you're going to make the following lease payments in whatever schedule, monthly, quarterly, whatever. There may be a down payment or not a down payment. And then on a particular date, the balance of the purchase price, which was previously agreed, so let's say the horse was $10,000, on a year from now or 6 months from now, you pay the balance of the purchase price. And at that time, title to the horse transfers to you. typically it's the same as this agreement, which says that the lease payments are going to the purchase price. A lease with an option, you typically apply all of the lease payments to the purchase price if the horse is ultimately purchased. But if the buyer doesn't purchase the horse, either they decide it's not a good fit for them, or they can't afford it, or whatever the situation is, the horse, you keep all the lease payments and the horse still belongs to you and is returned to you. The issue with the lease to own situation is that you would have to sue the purchaser in order to recover the horse under this situation, the way this contract is set up, because title would have already transferred. So it's not that it's a bad idea, or it's just very instructive as to what you might prefer if you're the seller to protect yourself.
And then just a few other things about this, this agreement is, it does require that the person leasing the horse will pay full board. So that sort of brings in a board agreement, into this, which I think we addressed in an earlier question. States they can't relocate the horse without express written permission. What we really like is the limitations on the use of the horse. So this is pretty specific. It talks, so think about when you're looking at your leases or your sales, or particularly your leases or adoption agreements. I mean, really anything, any of these agreements, you can bake this in, and it's limitations on the use, height of fences, where the horse is kept, who rides the horse, the ability and the frequency of the horse showing, care. This would be where you would include if a horse requires a specific supplement or specific type of feed or specific maintenance treatments, or specific other veterinary work or farrier work. You could also include, if you're dealing with an OTTB, include no racing, and that they would submit the form to the jockey club as sold, as retired from racing. So this section about limitations on use and care of the horse are important. The only other thing that I would have to say is on the care of the horse, it says if for any reason the horse must be euthanized, it does say if the horse is missing, lost, seriously injured, sick, or dead, the lessee shall immediately notify the owner by telephone. One thing that I've seen in leases is, what kind of efforts have to be made prior to euthanasia to reach the owner? I do at the farm where I board my retired horse, I actually had to fill out a section of the agreement that talks about, this is the number you call, and you have my permission to proceed if you can't reach me after a certain number of times, or in other cases, suffering, and to avoid undue suffering, or by veterinary advice. It lays out specifically really well what the owner of the farm can and cannot do, and the efforts that can be made to reach me, but also take care of the horse as well. So that's something that you can include in care of the horse. You can also authorize, veterinary expenses up to a certain number, and specify also insurance, which this next section does, about the risk of loss. But the big issues with lease agreements is, if the horse dies or is seriously injured, and these can be difficult because horses have a way of finding trouble. And so just think about the risk of loss, who carries insurance, whose insurance is primary. If I'm leasing a horse from Laura, her lease agreement's probably going to require me to carry mortality and major medical insurance on her horse. But it probably also states that if the horse dies and that mortality insurance pays out, that it pays out to Laura. It doesn't pay out to me, because it's still her horse. So those are things to think about and include in lease agreements. But think about it from who assumes the risk of injury or the risk of loss, and what do you want to do to plan or address that in advance?
So let me hop in here for a second. Kristen has a question in the Q&A. Let me just scroll back up here. So the benefits of using both a bill of sale and a purchase and sale agreement. So let me address that part first. So typically we use a purchase and sale agreement. That's a purchase and sale agreement is really an agreement to purchase a horse down the road subject to certain conditions. I typically use those only in sort of high dollar sales where there's going to be some sort of, for instance, with stallions, if we're selling a stallion, we have an agreement to purchase a stallion before Derby or a stallion prospect before the Derby, but there's a series of considerations before closing. Then we'll use a purchase and sale agreement. The second part of this question is, what about when consideration is $10, another good and valuable consideration, when the actual sales price is in the tens of thousands? So where I see that come up, and you can, whoever asked the question can jump in. Typically, like for instance, USCF requires that you provide them a bill of sale. And some people don't want to disclose the actual sales price because they don't want it to be public and they don't feel like it's anybody else's business. Then you can do a separate bill of sale that just says for good and valuable consideration, and that's fine. If the reason for putting the actual consideration in there is one, so that you get paid, and two, to make sure that people aren't avoiding reporting income or paying sales tax or whatever the case may be. But in general, you can have a bill of sale that does not recite the purchase price as long as it recites some consideration. Kristen, you tell us, we're at the 8 o'clock time. We're happy to continue or answer questions. The questions have been really good. So if people have specific questions, we can answer those.
I would love to. I mean, our attendance is holding strong. I would hate to miss out on the opportunity to look at the adoption contract, just so that we're covering, range of scenarios for our audience. So if we can at least look at that one other one, and then if you have any must cover things, let's hit on that too. But kind of move in the direction of wrapping up and allowing a little bit more time for questions.
Laura, do you want me to jump ahead to
go ahead.
Okay.
Yeah.
Okay. So just to talk for a minute about things to think about when you're looking at an adoption contract or an adoption agreement is we'll look at an example here and go through, but I want you to keep these in mind as we walk through the questions of what to include in the agreement. So what is transferred? Are you actually transferring title to the horse? Is it a lease with an option to buy? Is there a trial period? Things like that. Think about how you want to structure the agreement, and your adoption contract can have a trial period in it and still be essentially a transfer of ownership. Can be an adoption contract that transfers ownership and title to the horse and still bakes in language about a trial period. Is there an intake form? A lot of adoption contracts will integrate. A lot of places you have to fill out an adoption intake form. You have to apply. You have to provide references. You have to provide all kinds of information about where the horse is going to be kept, who the veterinarian is going to be, the intended use, your level of competence and experience, things like that. So if you have an intake form or an application filled out by a potential adopter, I like to integrate the information in their application into the agreement. And so that essentially makes the statements that they put in their adoption application warranties and representations about their competence, their level of experience, what they're looking for, where the horse is going to be kept, how the horse is going to be cared for. You integrate that, you just pull that all into your adoption agreement simply by having some language that says, references their intake and application, maybe attaches it as an exhibit to the agreement and says, this all comes in. This is part of the complete contract. like we talked about earlier, the option to board at a location. That this is where I tend to see it is in adoption agreements, where a horse may be boarded at the facility for 30 days before or more before the adopter can come and get the horse, or the horse is on a trial period and the adopter, but the horse is boarded at the facility and during the trial period of 60 or 90 days. And so the potential adopter is paying board to maintain the horse at that facility during the trial period. Also, the right of return or the organization's option to void the adoption under certain circumstances, such as non-compliance with updates, inspections, veterinary updates, things like that. Make sure you set forth your inspection and reporting terms. How often does the potential adopter have to provide updates to your organization? Do you have a right to go on their property? Some organizations require that wherever the adopter is going, wherever the horse is going to live, it has to be subject to inspection prior to approval, but also can be inspected anytime with 48 hours notice or reasonable notice for the first year of adoption, after the adoption, something like that. Prohibited acts, sort of like the conditions or limitations on the use of the horse that we saw in the last agreement. What are your enforcement mechanisms are going to be? What's going to work for your organization? How far are you willing to take it? Knowing that a lot of people are going to abide by them and be conscientious in that. The standard of care, the horse is going to be kept at the standard of care of a reasonable, the horse is going to be kept at a standard of care. Some of them say language like, in reasonable condition based upon the customary, customary standards of wherever the horse is going to be kept. Shelbyville, Kentucky, Shelby County, Kentucky, Central Kentucky, Kentucky, whatever. Or they can even be more specific and have a body condition score. The horse will always be maintained in no less than this score of body condition. If you're an organization adopting out, you always want to disclaim your warranties, just like any other seller. Yes, you are adopting the horse out, but you are just like any other seller and you need to protect yourself with a good warranty disclaimer. Also, you need to choose your choice of law and your choice of court. And what I mean by that is, say your organization is based in New Jersey, you're adopting to someone in Kentucky. And so you need to make a decision of, is New Jersey law more favorable for us on this, on enforcement and construction of the contract, or is Kentucky more favorable? And you need to specify the law of Kentucky will govern this contract if you want to go with Kentucky. But you also need to specify what court it is, because otherwise I could sue in New Jersey, or I could sue you in California, or I could sue you in Florida, and the court in those other states, then I can ask them, well, I want to haul you, New Jersey organization, into court in California, and then I want to ask the California court to apply New Jersey law on this contract. So you really want to think about where you want to litigate, because if you're the adopting organization or you're the seller, you don't want a buyer or an adopter hauling you into court halfway across the country and you having to spend more time and expense in litigating that dispute. So think about, a lot of mine in Kentucky say be governed by the laws of the Commonwealth of Kentucky. The parties agree that any disputes will be litigated in the state or federal courts sitting in Jefferson County, sitting in Fayette County, Kentucky, something like that. And I would also include, if you've got out-of-state parties that aren't in Kentucky, if you decide to choose a choice of law in Kentucky, all the parties to this agreement consent to the jurisdiction of these courts. And that's just kind of it's a belt and suspenders and some duct tape to make it easier for choosing where you litigate. And then the fee shifting provision on the attorney's fees. So let's go back to the link. the adoption. So this was the adoption agreement that we received in the link. And I think it's good in that it has the horse's registered name, which suggests that there is a registration. So obviously if you have, and it does have a place for a microchip and a breed, but if you have a registration number, a USEF number, or jockey club, just put all of that, identify the horse as well as possible. And I do think, and I think it would be particularly suitable for adoption agreements to include the 4 photographs of the horse as well, either embed them in the document or attach them to the agreement. You zoom out a little bit so you get a better flavor of, I'm just going to scroll down kind of slowly so you get a better flavor of this agreement. This agreement is, it starts off well in that it starts off with numerical paragraphs and it starts off talking about the agreement. But then as you notice, as you get further down, it starts looking a little different, and you've got a number 2 down here and a number 3, but you've also got a 1, 2, and 3 up here. You've got a 4 here. You've got a 4 here. So it looks like a document that has been updated over time, and the numbers haven't been updated. But just to go through some of my sticky notes to talk about things that I would call out here. And this could benefit from some better organization, as we talked about, is you want to address things topically, and you want to make it clear so that it's easy to follow the document and it's easy to find terms. Like everything about the care or the limitations on use of the horse are in one section of the adoption agreement. Everything about where the horse will be kept and when the risk of loss transfers will be in one section. I would start out with a good solid bill of sale for the basis of your adoption agreement, and then tailor that to address the fact that it is adoption related. So then you can add things like limitations on use, limitations on resale, right of first refusal, enforcement, inspections, updates that the adopter has to provide, kind of what I call the long tail terms. They're going to follow the horse longer than the immediate point of purchase. And you can use headings, use numbers, use anything that makes it easily organized. Some of these appear to be missing text. This says, agree in accordance with the charitable purposes of, but either it's missing text or it's supposed to be this next line and it's just separated itself out. Like I said, this is really hard to follow, and as a litigator, I could have I could make life a little miserable by going through the fact that the organization isn't easy to read, and some sections have a mix of different components in them, and really they just need to be organized topically better. This appears to be an additional section, but it's like an agreement by the adopter that the adopter is agreeing not, and it's good because it's good in some respects. Should not be found in a kill pen or auction. Otherwise, you're going to pay us money and hauling expenses, and we're going to hold the last person with a valid contract on the horse. So it's asking the adopter to initial these terms. And I think that's really important to make sure to help drill home that the adopter understands that these apply to them. But what I would do is I would simply set those out as the requirements for adoption and have the adopter just have a blank and have them initial next to it. But it just needs to be better organized. This is a good way to transfer loss. It identifies the moment that the risk is transferred, and that is when the adopted horse is loaded onto the trailer to leave its current location. So that's really specific, and there's not going to be a question about that. the return of the horses appears to be addressed in a couple different places. So that needs to be cleaned up and again, organized more topically. But it does have, you know, it allows the adopter to return the horse with at least 72 hours of notice, and that may be waived. And it makes it clear that the adoption fees are not refunded if the horse is returned.
So that's an important provision for rescue and rehoming organizations, because sometimes somebody needs to return a horse and they don't have capacity to take it at that moment. So putting something in there that says you have an absolute right to return it if you can't care for it and afford it is really important. But then putting something in there that says, however, you have to care for the horse until we can find a stall for it or have capacity to take him back.
Right. Yeah. Covers the resale of the horse. And again, this could all be kind of consolidated in one section addressing resale or limitations on the use of the horse. But it has a lot of good provisions. It's just they just need to be reorganized. This has the inspection and reporting requirements of regular updates. So I would suggest that regular is very vague. I would suggest, you know, maybe monthly for the first 6 months and then quarterly thereafter or something like that. Because you don't want the adopter to guess on what is a regular update. You'll get adopters who will send you pictures of their horse every day, multiple times a day. You'll get some that you won't hear from for a while. So I would be more specific in the adoption agreements and set that out up front so the adopter knows what is expected and the organization knows when an adopter has not met. It's also easier to keep up with from a calendaring perspective of these are the horses that we're due updates on this month or at this time. The location of the horse has to be set out, and the rescue has to be notified if the horse is changing locations for any time. And it says both verbally and in writing if the location changed. I would just put that in writing. I would just keep it to in writing, because that way you don't call somebody and they're like, oh, okay, that's great, send me an email, and then there's no email or the email is lost. You just go ahead and communicate it in writing. And see, then this has regular. So this is a little bit contradictory because it does say regular updates up here, regular updates including pictures, but then down here it says every 3 months for the first year, and it says what the pictures should require. So that should all be in one location and well organized so that the adopter can basically use it as a checklist of things they have to do and when they have to do them.
So I think Kyle raised a good point in the chat that their agreement uses the TAA standards, the Thoroughbred Aftercare Association standards, and the Henneke scale, which is a body score scale, which I've seen that in multiple adoption organizations. That's a really good standard, and it, you know, veterinarians are familiar with it and adoption agencies are familiar with it. That's a good way to handle it.
Yeah. Agree.
And then, Anne, there's a question in the Q&A, which is a tough one. It's a litigation issue, really, but which is, what's the best way to repossess a horse in the event of a breach of contract or a horse welfare issue? How does that typically work?
So it's going to depend on where you are. It's going to depend on which state you're in, and it's also going to depend on sometimes which county you're in and what the particular requirements are. You could file if they won't agree to let you take back the horse, then if you can't negotiate that and maybe have have discussion about that, maybe call out some local animal welfare folks or animal welfare agencies in the area to help intercede and help negotiate the return of the horse, then you're probably looking at having to file some sort of action in the local court for breach of contract, but you're also going to want an injunction, although an injunction usually keeps things the same, but you're going to want to pursue, go back to law school, the term replevin, where you go when you want the property back. And depending on the value of the horse, a lot of these could be done, at least in Kentucky, could be done in district court because it's for disputes that are valued at $5,000 or less. Others you may need to go to a circuit court. So the short answer is that it depends on your jurisdiction and your situation and where the horse is located, and how much money you want to spend on getting the animal back.
If you own the horse, so say it's a lease situation, is that a situation where you can get the local sheriff to go get it?
I would certainly try. Or I would have the sheriff, I would inform the sheriff and see if they would be there to oversee either you or a third party coming to get the horse. Just to avoid, we have title to this horse. We're entitled to be on the premises to come get the horse, and see if the sheriff can't at least be there on standby to facilitate it.
And then Chantel, who's in the chat, has asked if we could recap the attorney's fees section. So I'm not 100% sure if she means just how it should read or how to enforce it.
Yeah, I'm trying to think of the example that we had. It was in this, I remember what it was. It was in the lease to own. And there's different ways of doing this, but this is a pretty good one. And get my sticky note to go away. Oops. So this is the attorney's fees provision basically says that if there's a disagreement arising from the contract or enforcing the agreement, there's a disagreement and it goes into lawsuit or arbitration, then whoever wins is determined to be the prevailing party will be entitled to recover attorney's fees. So if you sell a horse, the buyer says, this horse isn't what you represented it to be. I'm going to sue you. I want to rescind the contract. I want my purchase price. I want all the money I've spent on the horse since I got them. I want all of that back, and I'm going to sue you for all of that. And you as the seller defend yourself and you say, hey, I have a really good bill of sale that has all of these great disclaimers in it. It shows that you tried the horse and determined their suitability for yourself. You've you either had a pre-purchase exam or you waived it. You go forward as the seller into court with all of your defenses, and the court agrees with you and dismisses their case. Then you as the seller have a claim against the buyer to pay for all your reasonable attorney's fees and costs incurred in winning the claim. Which costs you a couple $100s to file a lawsuit. It's much more expensive to get rid of one. So Chantal, does that answer your question? Can't see the Q&A without looking at my screen.
It's okay. Yeah, I think so. She was looking for the language, so that's up now.
Yes. Okay. Good.
Yeah. And then just to go back, Anne, can you just really quick go back to those Florida specific slides? I just want to show people why it makes a difference what state you're in. So in Florida, when they passed their equine bill of sale statute, they added some very specific provisions. So this is one of them, that you have to disclose if your horse has had shockwave therapy in the last 7 days, or any kind of acupuncture stimulation to the laryngeal function, or blisters behind the knees. So that's typically, these were probably really addressed or directed at the public auction sales, where you might have yearlings going through that have been blistered, or horses that roar or what have you. But shockwave therapy, we know, is pretty common now across all disciplines. So your bill of sale is apparently in Florida. So, neither of us are licensed in Florida, but this is in the statute. You have to actually affirmatively disclose whether or not this has happened to your horse. And then, Anne, could you advance a slide? This dual agency provision, I'm just giving you an example here of a Florida dual agency provision. We use a similar one in Kentucky, but cite the Kentucky code rather than the Florida code, obviously. But basically says you're aware that if there's a dual agency situation, so it's an agent who represents both the buyer and seller, that has to be disclosed to both buyer and seller and consented to in writing. So the thing about conflicts of interest is you can waive them, but you can only waive them if everybody knows about it. So if you have an agent, which happens frequently enough, that's representing buyer and seller, both parties need to know, and they need to know the economic details of that, who's getting commission and how much. And then the other interesting thing about the Florida statute is this very specific provision about how buyers and sellers have to sign the agreement. So there's this provision that states if you're signing as the purchaser or on behalf of the purchaser, so as an agent, that you understand that any reps and warranties from the owner or seller have been disclosed to you, including medical conditions and prior medical treatments, which Florida is big on, are in this bill of sale. So anything that's not in the bill of sale, not included. And then as the owner seller, that you're authorized to convey legal title. So these two provisions are supposed to be, in the signature section of your Florida bill of sale. The question is, what happens if you don't know this, or you forget, or it's not in the one you receive? There's a little lack of teeth to this. So Florida does, unlike a lot of other states, this then kicks you over if you don't comply to their Consumer Protection Act, and which isn't a great place to be as a seller. A lot of other states, I think Kentucky included, have said that the purchase and sale of horses is not a consumer protection issue unless you really are a true consumer. It's the first time you've ever bought a pony for your kid and you have no idea what's going on. Maybe you get the protection of the Consumer Protection Act, but in general, they're considered business transactions. So I just wanted to highlight that certain states have very specific requirements, and so know your state law. Kristen.
We're, as typical, we've got some questions rolling in here. Kyle has a really good one, but I'm going to leave it as kind of like the wrap-up question. So another one that just came in is, in terms of suitability, sometimes buyers represent their riding skills to be vastly better than they actually are, leading the seller to perhaps unknowingly misrepresent the horse to be suitable, especially when the horse is sold through an agent. Is this where as is provision covers the seller?
So that's a tough one. And this comes up all the time in the hunter jumper world. That's where it's super important. I think, Anne, if you can flip to that one slide that has the trial language. So I now am super specific about this, and I say in the bill of sale that you had a professional advise you and come with you when you rode the horse and advise you on the purchase and advise you on suitability, and that the seller makes no assumption about your riding level. They don't know anything about you. This is where you have to be very careful not to be on both sides. So if you look at this language that's up now, and then I go on now to include in here, because I've literally seen people try and return a horse a year later, that there's absolutely no right of return of the horse to the seller. Now, if you're a professional and it's a short time later and you think the best course of action is to take the horse back and resell it, or at least take it back on consignment because you want to preserve a future business relationship, that's totally understandable. But when someone does exactly what this person's asking about, misrepresents, their kids' riding ability, takes some $150,000 show jumper and pulls on it for 6 months and it starts stopping, that is not on the seller. And now it doesn't mean that very wealthy parents won't bring a lawsuit, but it's pretty defensible.
Okay.
The other thing I want to say, which has really saved a few of my clients in the past couple of years, I think Anne mentioned that anybody can sue for anything, and it's very inexpensive to file a lawsuit. It's very expensive to defend them. These organizations where you're selling or adopting out horses, or if you're a professional trainer, your insurance company can sell you professional liability insurance. And that insurance will pick up the defense of a claim for, misrepresentation, or a horse isn't suitable, or those sorts of claims. And the insurance company will pay the legal fees. Typically, you don't get to designate who your attorney is. They do, but they're usually pretty good attorneys that are screened and vetted by the insurance company. So if you can purchase professional liability insurance for what you're doing, that is a good thing to have.
Okay. We've had a scintillating 90-minute conversation here. No, I say that unironically, but I think, my comment in closing is, people, there's this kind of misconception. I'm glad that we talked about like repossession and enforcement a little bit, and that I think sometimes we think that like having a contract is going to keep bad things from happening. And we all, at least at the end of this session now understand that they're going to discourage bad things from happening and give you an opportunity to take action against, that entity for wronging, or violating the contract in any way. So, I think my thought is like, don't be shy. This is not an area for, you as a small business owner or as a nonprofit director to skimp. This is in everybody's best interest to spend some time and beef these things up. And really make it represent the things that are important to you and important to your organization and your horsemanship and how you want your program represented too. The wrap-up question from Kyle was, as these types of laws are changing from, state to state or within these different jurisdictions, like what is the best way to stay on top of these things? My inclination is, as a nonprofit organization, we're members of state nonprofit organizations, in all of the all of the states that we operate in. So we get legislative and legal updates like, summarized and pushed through. So I think definitely looking, if you don't want to learn the code yourself, which is, not necessarily what we got in the business to do, at least make yourself aware of your local nonprofit organizations or small business organizations, because they can be a really good resource. But, again, to the lawyers on the call, please add your thoughts.
I don't know of a good way. I mean, other than setting up Google alerts or something, having an attorney on your team who can say, hey, this just happened, or, they don't change that often. Those particular bills of sale statutes in Kentucky and California and Florida arose out of some big pieces of litigation that probably at the time everyone was aware of. But yeah, they don't happen very often. Getting state legislators to pass new legislation is like an act of God. So it doesn't happen very often, but typically someone will write about it. There's some, multiple law firms that have great alerts that go out when there's new information. If you just subscribe to some of those or follow those. And then I think, honestly, USEF, their equestrian magazine, the Chronicle, there's several others, probably Kirsten's Association, who publish magazines or newsletters or bulletins, typically will alert you to what's going on, that if anything has changed.
I agree. I don't have anything to add. They don't change significantly. Know what your UCC for your specific state says, know if what your limited liability act is, if you have one, and whether it requires mandatory language. So it's like getting a good getting a good starting place, a good thorough starting place, and then asking the questions about how the agreement is going to be structured and what the intent of the parties is going in kind of helps refine and tailor each sale or adoption or lease, tailors it so that it is specific to that transaction.
I think from a nonprofit perspective too, like I would just add, like, you know, your board is supposed to be, you know, a supportive resource for you as well. And I think it is never a bad idea for any nonprofit to have, you know, a legal professional on their board that is going to at least, you know, may not be like totally keyed in, you know, specifically to the issues that you have, but are going to know where to help you find the right resources. You know, RRP has been through things recently in making like programming decisions and what the implications are, you know, from a tax perspective and that sort of thing. And we had to go find like a very specific tax attorney to help us answer some questions, but we were able to do that because of, you know, the network that we have and from within our board. So, you know, keep that in mind. And that really goes not only for nonprofit organizations, but also small businesses as well. You know, your network and particularly in horses, like you've got people that can afford to ride horses that are doing this type of work. So, you know, look around and see who's in your community that can, you know, help steer you in the right direction. Mayor Worthy will happily welcome Anne or Laura to our board. Well, I've got first dibs on Laura when she's done with her current, so you're gonna have to get in line.
That made me laugh. For some reason, I can't respond in the chat to everyone. I can respond to Kirsten, but not to everyone else, which again, that made me laugh out loud. But I would say, Kyle, you seem to be totally on top of it. Like you're like, we use this provision and that provision. They're 100% what I would use. So good for you.
Asking the good questions.
Yeah.
Not surprising. All right, everybody. Thank you so much for your time this evening. Again, we are about halfway through now with Aftercare Industry Month, and I'm going to sign off because these are the two sessions that I am tasked with. My colleague, Kristen Kovach-Bentley, will be hosting the next two sessions, which cover networking within the industry and how to place horses with limitations or other types of problems that might make them difficult to place. So see you right back in this space, 7 p.m. next 2 Tuesdays, and more information is available about our upcoming sessions on our website, www.therrp.org. If you have any follow-up questions for the session, please don't hesitate to get in touch, and I can route things through to Laura and Anne on your behalf. So.
Thank you, everybody. We really appreciate being involved.
Yeah. Thank you so much, guys. Have a great evening.
Thanks, Kristen.
Take care.